Let's talk about charging the defendant and plea bargaining. At the arraignment, this is where the defendant is learning the actual charges that he or she is charged with. The police, when making the arrest and bringing the defendant to court for arraignment, can certainly hand and provide the individual with copies of the charges and say, I'm charging you with, and say what they are. But there's a lot of times it's arraignment is where the defendant is hearing the charges for the first time and who is actually accusing the defendant of those charges. And even, regardless of whether they were notified ahead of time, this is where the official reading happens on the record. You have a right to know what you're being charged with and who's accusing you. And, this process is slightly different depending on the jurisdiction, what's coming up next. But the Constitution says you have a right to know the charges and who's accusing the defendant of those actions that resulted in the charges. So the process, as I move forward here, the book is starting you at the felony level, but I think it's important to know about misdemeanors and violations as well. In New York and in any other jurisdiction, this will happen if it's a misdemeanor or violation. This arraignment will happen in a justice court or some lower level court, a city court, a village court. What happens is the documents, the violation or misdemeanor is what we're talking about right now. The documents are filed by the police department. And those documents are called informations. That's their title, capital I, information. And it has to state the actual crime charged and the elements of the crime and how the alleged conduct fits those elements. That's what has to be in that document. The judge will read the charge itself, word for word, to the defendant, and also read any of the supporting statements that go along with this. The defendant can waive the reading, but that's what has to take place. And then the defendant will enter their plea of guilty or not guilty, and the case will remain and conclude in some fashion in those lower courts. And we're talking about misdemeanors or violations. They might have a trial, there might be a plea bargain, it might get dismissed. Whatever happens, it'll resolve in that lower court for misdemeanors and violations, and it starts with the police charging and filing the paperwork in those courts and then providing a copy to the district attorney. All right, so now we'll talk about felonies. Felonies, a little different. Police can file a document called a felony complaint. And I'm using New York as an example, but I'm pretty sure this is consistent in any state. Felonies can start a number of ways, but 2 ways, not a number of ways. In either one of these ways, the police can file a felony complaint in a local court, a small-time court, justice court, city court, village court, a local court, lower level, charging a felony. But should the prosecutor wish to pursue a felony conviction on a case, they must submit the case to a grand jury. The reason this allows for the filing of a felony complaint in a local court, because after the prosecutor reviews the case, they might, in their plea bargaining process, or just after reviewing the case, they may feel it's not a felony, or if plea bargaining may reduce the felony to a misdemeanor, then it can resolve in that lower court, not having to clog one of the bigger court or the felony court of the state. So it's a good avenue to have this felony complaint available. But like I said, if the prosecutor wishes to seek a felony conviction, there's a different process. And New York State's Constitution and the U.S. Fifth Amendment for federal court, in the New York State Constitution says the defendant has a constitutional right to have their case heard by a grand jury. So if a case has been filed in one of these lower courts as a felony complaint, the prosecutor must advise the defendant that they are presenting the case to grand jury, and should they wish to want to appear before that grand jury and testify, they may do so on such and such a date. Of course, there's a lot of rules with regards to that. I'll get to in a second. But if it's something that's been under investigation and the defendant doesn't know about, maybe the defendant's under investigation. A lot of drug cases are this way. There's, confidential informants who are doing, secret buys and acting for the benefit of law enforcement. After the investigation is over, the prosecutor will present the case to a grand jury. If it's this instance, the defendant does not get notice of the grand jury or his or her right to testify at grand jury, because they weren't even aware that they were being investigated. So what's the role of the grand jury? It acts as a independent investigation body into criminal activity. It's usually secret. It's not a public forum. People can't go in to watch grand jury. And they have to determine whether or not there's probable cause for the charges. Does the prosecution have a basis to charge this person with a felony? And the federal system has a grand jury process. Not all the states have a grand jury process. They have something else we'll talk about in a second. New York State does have a grand jury process. And, it determines whether the accusations of the state justifies a trial, or put another way, the people have a basis or probable cause to seek the felony charges. And this process is done at the request of the prosecutor. In secret, generally. They're the ones that put on evidence. They don't put on all their evidence. They just have to put on evidence enough that they can get to the next step. The defendant doesn't participate. Defense counsel doesn't participate. The defendant does not have a right to testify on their own behalf, but they do have a right of notice of grand jury presentment and the ability to testify if they are aware already of the charges. Say they were pending in a lower court. But it is not a trial process. There is no cross-examination. The defendant comes in, waives their right to remain silent, and is subjected to prosecution questions. The defense counsel does not play a role. So it's certainly not advantageous to have someone go in and try. Basically, they try and explain their side of things. And it's not the trial level. So decisions. Let's talk about a grand jury's decisions. If the grand jury decides that there's no probable cause, then they're going to issue something called a no bill, which means no indictment is filed, no document relative to the charges. If they find that there is significant or there is enough evidence for probable cause to have those charges, then they'll file a document, sign and file a sealed document called an indictment, which lists the charges that the defendant is going to be charged with. It's sealed and it's only opened by the court at the time of arraignment. That's the second thing that can happen. The third thing that can happen at grand jury is they can reduce the charge. They might say, well, that is not a felony, but it might be a misdemeanor, and they can reduce the charge and send the case back to a lower court, or tell the prosecutor to file a prosecutor information with a lower court. So 3 things: they can no bill it, say you don't have enough here, prosecutor. 2, they can issue an indictment, which says the prosecutor has enough evidence to charge felony charges. Or 3, they can reduce the charge. They can say this isn't a felony, but maybe it's a misdemeanor. So that's what the grand jury is and does. Not every state uses the grand jury process. Some use this concept of a preliminary hearing. process. And what is the preliminary hearing process and how does it differ from grand jury? First, it happens before a judge or a magistrate. It's an open court. All parties are there, and all parties get to participate. The goal is the same, though, to determine whether or not there's probable cause exists to charge with a felony. It's the judge who decides whether probable cause exists, and the prosecution has to prove that. And if the court finds probable cause, a prosecutor's information is filed with the court, and they can then pursue their case as a felony. If there's no probable cause, the charges are dismissed. Benefits to this type of process versus grand jury. If the defendant, let me back that up a little bit. Do you think there are benefits to this type of process versus grand jury? That was my question. And you could probably see some benefits that, the defendant gets to participate, right? The defense counsel gets to take a crack at witnesses and ask questions and see what the case is about. What do you think? The defendant can waive this process. Can also waive the grand jury process too. But the grand jury is done in secret. It might be more advantageous to waive the preliminary hearing because it's public. The public courtroom the public can come in and watch. Speeds up the process, especially if there's a confession that was not taken in violation of a defendant's constitutional right. It avoids any negative publicity. It's a high-profile case. Usually waiving the grand jury process or waiving a preliminary hearing process is usually done if the defendant is going to enter a guilty plea or accept a plea bargain in some instances. For this hurdle, New York State actually recognizes the preliminary hearing stage as well, but it does not do away with the grand jury. There's the potential of having both a preliminary hearing and a grand jury. I'll tell you when it comes up, most defendants waive it because of the grand jury process. But a preliminary hearing, because we have a local court system and because the police can file felony complaints at the local court level before they get to, our higher court or county court, the one that hears the felonies, and the defendant is aware of the charges. If the defendant has a criminal history, and the criminal history includes 2 prior felony convictions, then the court can't discuss bail with the defendant. The defendant's required to be held. And usually they'll opt for a preliminary hearing to determine whether or not there's probable cause to hold them on felony charges until the case can get to a county court and a bail review can happen. So that's why New York has the two components. All right. Once the indictment or that prosecutor information is filed with the felony court now, which is county court in New York State, defendant is arraigned on the charges and read the indictment and read the charges against them. The court will read it, make sure the defendant understands the charges, the allegations that are made, and the defendant's rights associated with going forward on a criminal case. And then the defendant will enter his or her plea, which is guilty or not guilty. And I thought I do have another slide, don't I? I do. Arraignment. Discuss not, they can discuss at this point where it's going to be not guilty by reason of insanity. In some states, no contest or nolle contender is a process that does not exist in New York. What it means is I do not wish to contend. There is no option for that in New York. It's guilty or it's not guilty. There is a plea of not guilty by reason of insanity, but it doesn't happen at arraignment. It happens later on in the process, should the defendant wish to use that as a defense. But to expand on the no contest, basically what's happening is the defendant doesn't accept or deny responsibility, but agrees to accept a punishment. Basically, the point is there's no actual admission of guilt. This kind of happens more appropriately in traffic cases, sometimes in assault cases, because of that, they may have very well engaged in the conduct, but they don't want to make an admission a lot of times due to the fact of a companion civil lawsuit for damages. If you have a traffic case and there was a traffic accident and somebody is charged with, running a red light and they slammed into another car causing injuries, and there's a personal injury civil case for money, you don't want to go into court and plead guilty to charges, right? Because those can be used in the civil case. So that's where no contest tends to come into play. Defendant pleads, let's say the defendant pleads not guilty. The court's going to schedule the matter for the next step. It's usually a conference. At that point, could issue a trial date out in advance for calendar purposes because the defendant is entitled to a speedy trial. So the court's job is to keep this on a tight track. However, the defendant does get to make certain requests, certainly certain requests for hearings that they're entitled to, whether they're subject to interrogation or an illegal search or some sort of when they're stuck in a lineup, those things can be tainted. So there's a number of hearings that the defendant can request and is or are entitled to, and that would move the case forward. If a defendant pleads guilty, which I said they can do at arraignment, but it's unusual. But usually this is coming because there's an acceptable plea bargain. The court is aware that at arraignment the defendant will be entering a plea bargain. It just doesn't always happen out of the gate where the defendant shows up, is picked up on an arrest warrant, and an indictment is unsealed and the judge is reading the charges. It's rare that a defendant will say guilty at that point because there's a number of steps, and a counsel has to review the DA's file and determine whether any rights were violated before you can finish a case one way or the other. All right. However, if the judge does take defendant's plea to guilty, the court has to ensure that all constitutional parameters are met, and this means that the judge will indicate to the defendant before the court takes the defendant's guilty plea a number of rights. The court has to state that he or she is afforded a certain number of rights, and by pleading, you're giving up those rights. The court has to inform of the sentencing outcomes, what the maximum sentence could be if it's not agreed upon already in some sort of plea bargain. And the court has to establish that the facts, as alleged, support a finding of guilty of the charges. This is very important because a court cannot let a defendant plead guilty to something that they didn't do. Some defendants just want to plead to get it over with, and when the judge starts asking about the facts and they're like, yeah, but I was drunk, or but I was protecting myself, and the court hears that there's some sort of defense, they're not going to let the defendant plead guilty. So this is what the court has to ensure happens, that if somebody's going to take a guilty plea, the court has to ensure that, in fact, they're guilty of the charge. So the court will read the charge. You're charged with murder in the first degree for allegedly beating the victim with a bat, and the victim died. Is that a true statement? That's a simple version of doing an assessment of the facts. But again, if the defendant says something like, yes, but I wasn't in my right frame of mind, I was wigging out, then the court has to explore that a little further or stop the proceeding. So court has to ensure that the constitutional protections are in place. All right, that's charging the defendant. Let's talk about plea bargaining, because this is what happens more than 90% of the time in criminal cases. There is some sort of plea bargain. After arraignment, and sometimes before arraignment, if everybody is aware and together and discussions can happen, and sometimes that does happen before we even get to the arraignment process. But after arraignment, generally, and before trial, discussions will transpire between the prosecutor and the defense attorney to see if the case can be resolved without having a trial, right? So what's a plea bargain? It's a non-judicial settlement of a case where the defendant enters a guilty plea in exchange for a reduced charge and or sentence. So it's one or the other or both. And they are reflected in one of a few ways. Initial charges can be reduced to a lesser offense, and the side effect of that is that the sentence is automatically reduced. If there are many charges, may reduce the number of counts and plead to the most serious and dismiss the rest. That can happen, or one or two of them and get rid of the rest, and that also reduces exposure or the sentence. Can plead, that other form of a plea bargain is plead to the charges, but the prosecution recommends a more lenient sentence, maybe no jail, maybe just like a supervision in some fashion. When a charge that has been charged has some sort of negative label attached, like child molester, the charge may be altered to a more socially acceptable one, like assault. That can be part of plea bargaining. In addition, it can alter to reflect or avoid what I call collateral consequence. Let's say DWI. We got a DWI case. And if somebody's convicted of driving while intoxicated, they can lose a driver's license. If they have a commercial driver's license in New York State, they can lose it for 5 years, which ultimately would result in a loss of job usually. The prosecutor may agree to a plea to something like reckless driving or some other offense where the collateral consequence doesn't happen. Is this good or bad? I'll say this is common practice. More than 90% of the cases result in plea bargains in state court. Federal court, that number is even higher. I think it's more like 97 or 98% plea bargaining. Is that good or bad? We got some pros and cons, certainly. The pros, judicial economy, that's the number one. Overall costs, right? Taxpayer dollars are at play here. And improves the court system. The court is very busy, right? It makes it more efficient. The prosecution can focus on more serious crimes, and more time can be devoted to those, and having those trials in court for the defendant allows avoiding being detained and avoiding having to go to trial and having a jury decide what is to happen. And, overall devotes the resources to cases that need greater attention, which are usually the more serious cases, like murder, right? Child sex offense cases, there's a lot of resources devoted to those. There's also a lot of resources devoted to DWI as well. Cons: innocent people plead guilty. Don't trust the system. They think that if they don't take a plea offer, it can get worse for them, because now they're facing a trial, and then the judge ultimately hands down a sentence. At least when you're plea bargaining, you know what you're going to get. It also allows serious offenders to get some leniency. Gives prosecutors a lot more control, right? What if a defense attorney doesn't have a good working relationship with prosecutors? You would think that both sides would be impartial, but their personal feelings for each other certainly play a role in plea bargaining. There's also this idea that defense attorneys don't try. They don't think about trial. Oh, we got a good case, let's go to trial. They're already trying to work out a deal. If you're familiar with the movie A Few Good Men with Tom Cruise, it's an older movie, but it's a great movie. It's classic. Few Good Men, Tom Cruise, the attorney, but he was a plea negotiator. His dad was a big trial attorney, but he was afraid to go into court, so he kept getting deals. And his assumption was that he can, it's the best route to go. Also, we have public defenders who are overworked, big caseloads, so, their goals are to plea bargain these out. So, cons to plea bargaining as well. When a defendant decides to take a plea offer, it is the decision and solely the decision of the defendant, not his attorney. This was actually a decision from the Supreme Court. It's the Supreme Court. The Supreme Court said the defendant decides whether or not they're going to take a plea offer. Counsel must be effective, right? Their job is to protect the defendant from undue pressure and influence. And that's actually one of the questions the courts ask a person before they take a plea. Has anyone promised you anything? Are you doing this freely without any undue pressure or any influence? They ask that question. Some defendants feel like they don't have a choice. I don't have a choice in the matter, I take it, but they do, right? The choice is you're entitled to a trial. It's a constitutional right. Technically not entitled to a plea. When the defendant decides to take the plea, like I said, it must be done voluntarily. The judge will confirm that. Each side must keep their promise to the plea bargain. If the defendant accepts the result or conditions, the defendant must accept the result and the conditions. A condition might be, we'll give you this lesser sentence. You don't have to go to jail, but you have to testify against your co-defender. And they will have to keep that promise. Most of the time, the case stays open until that happens. The judge is the one that has to ensure before taking the plea that a defendant is doing this plea voluntarily. They weren't forced, they weren't influenced, they weren't promised anything that was not outlined in the agreement, and that he or she has consulted their attorney. So all of those things must happen. What if the prosecutor says, if this plea is not acceptable, we're going to proceed on a more serious charge and we're going to seek the maximum sentence? Is that undue influence? Does that sound like undue influence? That is said all the time. This is our plea offer, take it or leave it. If it's not acceptable, we're going to proceed on this more serious charge that has a more serious sentence, and we're going to seek the maximum sentence from the court. It sounds like undue influence, but it's not. That is not undue influence, because you're not entitled to a plea bargain, and the prosecution has a lot of the bargaining power. So no, that's not, because the defendant still has a choice, and the choice is to go to trial. It's not the defendant say, you know what, I don't want to take that, but I'll take this. This is what I want. And the prosecutor will say, no, that's our job. Our job is the one to give you the plea offer. So, interesting position. Like I said, prosecutor has lots of discretion. Should the victim play a role in plea bargaining? There's absolutely no requirement. We've talked about the victims already. There's no requirement that the prosecutor consults the victim. Actually, they don't even have to talk to them about it. But if they are investigating the strength of their case, you would think a conversation happens with the victim. But they don't have to tell defense counsel that they've talked to the victim. But think about a victim and weighing in on what should happen. Certainly they ask, most prosecutors ask the victim or tell the victim what they're looking for and doing and why they're doing that. But victims are fueled by revenge, right? Emotions. They don't know the court system. So the prosecutor is not required to defer to a victim's request. Before we actually turn to pretrial diversion, there's actually something that is not in the book that I think is important that I just want to touch on real quick. I've already alluded to it. And it's also part of the pretrial stage. While plea negotiations are occurring, the defendant is making motions and requests of the court, right? They want to know if it's a drug case, if the confidential informant's reliable. They want to know if, something was taken from the defendant's car or house or from their possession. They want to make sure that the search was done not in violation of the Constitution, whether if, Miranda warnings were given, if there was an interrogation, and how did that, confession come about. These are all things that affect, the trial stage. They take place in the trial stage, and they could affect, the trial, but most importantly, they affect plea bargaining. The more the defendant seeks to have these hearings, the more the prosecutor drags their feet about a plea bargain. You start making the prosecutor have to do work because they have to prove these things beyond a reasonable doubt at each stage that the law enforcement act properly. Then the plea bargains tend to get worse as you go along. Unfortunately, that's real, and they have an effect. And at some point, the prosecutor goes, after too many hearings, they go, well, you can just plead to all the charges and leave it up to the judge to decide your fate, or we can just have a trial because now we've prepared all the way to the end. And they have a big caseload. So hearings are happening during the pretrial stage as well. Pretrial diversion. Let's talk about this. This is let's call it our specialty courts section. This is the treatment court programs that we talked about. This process suspends the criminal proceeding, allows defendants to complete a community program and it's under court supervision. This allows the defendant to avoid having a criminal record. It also allows them to continue to live in society and work and support their family. And if, the victim was out any money or property damage, to make restitution, make them whole, pay them back, complete any rehabilitation services. And in the end, the case could ultimately be dismissed or charges reduced and the case sealed, so the person doesn't end up with a criminal record. As I said last time, there's kind of disagreement over whether these programs are more successful than the traditional justice process, but I've seen both, and I think I told you about both. I have success stories, and I have non-success stories, and I think it just comes down to the motivation of the individual. A success story: student SUNY Plattsburgh. This is a few years ago now. There was a big drug bust on campus, or a party held by a student off campus, and some folks had possession of cocaine, it was, and I represented there was a bunch of students involved, and I represented one, and he did have a drug problem. He wasn't from this area, but I convinced the judge to let his case be overseen by the county where he lived, so he can do treatment there. He went to a special treatment facility out of the state of New York, and the judge allowed that to happen. And this took a good 17, 18 months, but the student did everything they were supposed to do. They even got back into school after being suspended and came back, and the judge dismissed. He had 3 felony charges, and the judge dismissed it, hotly contested by the prosecutor. And he's doing great. I heard from him about a year later, and he's telling me everything that he's been involved in. So these programs work. Otherwise, he was charged. If we didn't have pretrial diversion, his charges were mandatory prison sentence. They were high levels of drug charges, drug possession. So I believe it's a good avenue to have in light. And like I said in the previous discussion on this, there's an application process, and a lot of things are looked into. It's not a decision to take somebody into the program like willy-nilly. There's a determination of whether or not the person could be successful based on past review and experiences. So that is the charging of the defendant and the plea bargaining stage and pretrial. We're up now going to take a look at the actual trial process.